We will start with the miscellaneous application, miscellaneous 4868 of 2024. Davis Luchuma. Davis Luchuma. Yes. Nick Irima. Ilias Imani Kwapi. Kujeni hapa. Ian Obongo. Hassan Gidinji. Elias Victoria Ochien. Odiambo Ojiro. Ademba Alan. Emmanuel Ongua. Morgan James Amboko. Benjamin Mwaura. Stephen Owoko. James Ochieng. Joshua Okayo.
Viva Comrades, viva.
Fabian Ochieng. Dayo Ahamo. Philip Onyango. Dalian Muzeni. Cyrus Waweru. Nicholas Karanja. Wayne Ouma. Okiya Omtata. Kwa wale nimeita majina, kuna mtu yote hapo chini ya miaka 18. Is there anybody who is under the age of 18 years?
Please the court. I'm Martha Karua, Senior Counsel, appearing with my senior colleague, Senior Counsel Kalonzo Musyoka, Honorable Eugene Wamaro, Honorable, not Honorable, but there was Honorable, but the title is not there yet. Yes, the title is not yet confirmed, but he is indeed Honorable. Simon Boro.
I'm present here.
Simba. Oh, John Minor.
I'm present here.
James Omamo. James Omamo.
Present.
Kelvin Walumbe. Senator Manso.
Present, Your Honor.
Ian Motiso.
Present, my lady.
Kabata Mano Hussein.
Mano Hosea, Your Honor.
Permit my poor eyesight. Your Honor, and Miss Kabuda Mudama. Anybody else have left? Oh, we have Mr. Victor Kamau appearing on behalf of the Kenya National Commission on Human Rights.
Present, Your Honor.
Anybody? Bob Okumu. Juane Shago. Your Honor, we have a preliminary objection to the charges, but in view of the time, we are wondering whether you could give us a date for the preliminary objection, but in the meantime, we canvass bail. And Your Honor, looking at the charges, you can see It's what one would call omnibus offenses, which the police use when there is not reasonable charge to prefer. Charges merely being used to ask for the holding of the accused persons in custody for 15 days. I've seen an affidavit suggesting that, which is really outrageous. So we'd like to ask, because our submissions on the preliminary objection will be lengthy. The accused persons have already been in custody for more than 24 hours. Because the time they were arrested yesterday and the time they have appeared before you, which is 1:30, they've been in custody for over 24 hours. We would want the court's indulgence that we apply for bail, and you do give us a date for us to come ready for the preliminary objection to these charges. We do believe that the accused persons are before the court for being patriotic tenants and for being peaceful, for following the abductees, which is a matter of public knowledge, for staging a peaceful process. So we are saying, in other words, the background to these offenses is a matter of public notoriety, which the court can take judicial notice on, and allow us to go straight to bail application and to kindly give us a date when we can come and make objection to these very outrageous holding practices.
Essentially, what your Honor, senior counsel is the court is to defer the hearing of this application. We want to reiterate that we are appearing for freedom fighters who are fighting to liberate themselves. So, Your Honor, the application is that we defer the hearing of this application and we grant bail to the suspects. Of course, Your Honor, I refer you to Article 49, Clause 1, Paragraph H, which provides that an arrested person has a right to be released on board or bail on reasonable condition, pending a charge or a trial. Pending a charge. That is the basis upon which our application is made. This is not the first application of this nature. They have been made previously, and noting that the application that we shall canvass in the future, if the court is obliged to hear us, they are only proposing petty offenses, misdemeanors. When you look at that, my Honor, as against, again, Article 49, Clause 2, it provides that a person shall not be remanded in custody for an offense if the offense is punishable by a fine only, or by an imprisonment for not more than 6 months. So, Your Honor, our application is well seated in within the four corners of the Constitution. You grant us bail pending the hearing of this application. The application has just been served upon us. The application presupposes to investigate petty offenses and to not prejudice the applicants in whichever manner if the application is granted. We must oblige.
Before the Your Honor, if I may, my name is Mano Jose. On behalf of the Law Society of Kenya, I want to bring to your attention the constitutional petition number E714 of 2024, wherein Your Honor, Mr. Okiya Omtata, who is a respondent in the application so presented in court, is the third interested party. Your Honor, in the said petition, Justice Bahati Momunyi has issued orders that touch the subject matter that is before you, that is the demonstrations and also the abductions. So that, Your Honor, any directions issued before you this morning might be contrary to the Superior Court's directions issued today, this afternoon. As we speak, and I think Senior Counsel Kalonzo Musyoka and Martha Karua were in that court. Your Honor, we supply a copy of the court's directions that were issued yesterday, and we endeavor to supply this court with the directions that were issued this afternoon. So that, Your Honor, if any directions that you will give, we seek that they be subject of the directions that have been issued by Superior Court. Perhaps after this 8th, when we are appearing before that court for further directions. That is our prayer. Let me just start from here on the left. Women will be presented some court proceedings before justice was moved. And women are like to submit that those orders do not touch on matters before this court. The Honor is mostly of these proceedings in Parliament. The application that is before this court today is merely seeking custodial order against the third respondents having been arrested yesterday. The said application supported by an affidavit by one Corporal Anthony Kelly, whereby he is seeking.
Your Honor, my apologies to interject. The prosecution seems to be prosecuting the application. However, Senior Counsel had indicated that we need to before we get to the substantive hearing of that application. Because the court will kindly give directions on the request by Senior Counsel, and then we are able now to take proper directions in whether the DPP prosecute that application or not.
Unfortunately, I'm cut short. I was making a basis of what is before this court. Your Honor, the application before you is seeking custodial orders for 14 days. Your Honor, if you go by what the Senior Counsel was saying, that we directly dwell on the issue of bail, we will have already canvassed this application here. It will have been spent because the application before you is seeking for custodial orders against the 23 respondents, so that the IO can achieve 1, 2, 3 issues that will enable him to charge the same participant. If we go directly and say that we have a big release on custody, it will already be, the application will be an academic exercise. So before
any description, they didn't carry any stones, even if anything, they chained each other, making it even more difficult for them to move. Peaceful Kenyan demonstrators. And therefore, Your Honor, for anybody to say an affidavit wanting to hold them for 14 days is going against the spirit, the letter and the spirit of Constitution 2010. They are not, we do not know Nobody is actually saying, because the only reason you can hold Kenyans is if they are, for the kind of period the prosecutor is talking about, is if they are suspected to be terrorists, in which case they would have been arraigned before a court, I think a terrorist court, something in Kiambu. And therefore, Your Honor, we strongly urge that this court protects the right to peaceful demonstration. We believe there's absolutely no reason to hold Kenyans who have been singing peaceful, patriotic songs. That is not an offense. Your Honor, we urge that you come to the help of your country by dismissing this application with the contempt it deserves, because it is unconstitutional, it's even unethical, and it defeats logic.
Your Honor,
We don't have a because there are some issues that are coming up, matters of trust and all. I think the court should just give us a direction in regards to whether the matter to proceed or the deferment of the proceeding.
I think, Your Honor, he has already made this application. Even though I had objected, he has made his application. We are now responding. So he must hold his peace. We respond, because what else would you have to say other than what is in the affidavit? You've already objected to any application. So let us respond to you. We have something to say. I want to be last to let my colleagues go now.
Your Honor, I was not I was cut short by my colleagues.
Maybe
and it can go on record.
I had the pleasure of appearing in the matter 249/2024. This is the state regarding Boniface Mangi, and I appeared alongside Senior Counsel Martha Karua. The charges, whether which are being referred in the application, there is a recommendation, a letter which was issued by the ODP in regards to the copy-paste. This is creating disturbance, which has actually been listed there, and lawful assembly, which has been stated there, and also section 79. And the upshot of this particular letter, which was signed off by the acting director, that was Dorcas Ratgat. Consequently, the DPP directs that the evidence presented has not met the evidentiary threshold to warrant approval for the proposed charges. Therefore, the application to actually be, the persons be actually granted bail is actually rightly before this court. The prosecutor meeting, rather trying to prosecute the application in itself, it does not stand in itself.
Your Honor, with your kind permission, my name is Daniel Manzo, representing the team which has been presented before you. Your Honor, Article 49 and 50 are clear as to the rights of an accused person. And one of the rights is right to bail, which would have been issued at the police station, which can be issued by this court. And further to that, all constitutional issues, Your Honor, are already raised in the petition presented before you, and therefore nothing forbids you from going on to exercise the Constitution and release accused persons on bail pending the hearing of this particular application, which Your Honor we submit will be lengthy. We'll present all the laws dealing with this. And belonging to the senior bar, Your Honor, I'll tell you this happened years before. before 2000, and the responses and the precedence is very clear what happens in this particular sort of thing. In fact, it has not happened, Your Honor, for the last 25 years. And therefore, we want to canvass it conclusively under the new constitution so that all Kenyans, Your Honor, are happy with it, and that the court cannot be rushed into just agreeing with the police officer who sworn an affidavit here, which in the first place is defective, and secondly, discloses no offenses. For there to be a charge sheet, Your Honor, there must be there must be an offense which is disclosed on the face of the document. I thank you, Your Honor, and agree with my seniors that the accused person be first and foremost be released on bail.
Now giving my directions on whether we are objecting or proceeding.
And I'm address the court on the issue of the application amounting to an application really for pre-trial detention. Your Honor, I have had the affidavit read to me. It does not disclose what security risk they are not even accused are going to subject if they are released before that 14 days. They have not really indicated what nature of investigation are pending and which they couldn't have investigated by yesterday. They have not indicated at all with what charges they propose to prefer. So, Your Honor, stripped of everything else, this application is just a sham, farcical, a facade, a hoax, merely intention at keeping the person before you incarcerated. Your Honor, as the Constitutional Commission that protects and promotes human rights, we are exceedingly cautious and apply ex abundante cautela, an abundance of caution before granting any such application. So, Your Honor, we wish to urge this court to actually release the accused person. In fact, not accused person, sorry, I'm mistaken. To release the person before this court, possibly on free bail, because there is even no determination of the felony or misdemeanor they have committed. There is no determination of it. And therefore, you can't even, according to the bail and bond guidelines, you can't really even set proper bail. So, Your Honor, we urge you to err on the side of the Constitution and release the person on a free bail. That is all.
There are a few issues as an officer of the court I think I should bring to the attention of the court as you make your ruling, Your Honor. Yesterday, I went to the Gigiri police station where Okiya Omtata was being held. They refused to let me. I was with senior counsel Kaminwa, Dewantiru, and several other lawyers and civilians. They refused to let us see him. His brother was present with his medicines. They refused to give access for him to have his blood pressure medication. And later on, they transferred him to Kamukunji, and we were not able to see him, and I know he was not able to access his medicine. I'm bringing this to the attention of the court. One, he's been brought after 24 hours, because he should have been brought early morning, but they have delayed until 24 hours are finished. They held him incommunicado, and it's the same for all the others. I'm informed by my colleague counsels it was the same for all the others. In view of these illegalities and impunity, and the fact that it has already been mentioned that the way the affidavit is, you can clearly see there is no offense disclosed, a sufficient expedition. And if you look at Article 49, it's the rights of the accused, not the wishes of the police. Because this is a wish list they have brought that give us these people for 14 days. It's the rights of the accused or anybody held in custody. So the application is brought under sections that protect the rights of persons arrested, not gives the police the power to continue abusing the law. Article 36, not article, but section 36 of the Criminal Procedure Code also cannot come to their aid. I'm therefore urging you not to even go to consider bail, to just reject this application forthwith and set the gentleman, am I seeing any lady there? The gentleman before you at liberty forthwith. And it's a matter of public knowledge that they were peaceful, they were seated, demonstrating, but the police and administration in this country have criminalized legitimate activity. So instead of looking for the abductors and punishing them, they are punishing people who are asking why and where are they. So there is no charge here for us to discuss. Kindly release these persons, set them at liberty forthwith, let the police retrace their steps and come to their aid. Actually, this is an embarrassment and an abuse of the process of the court.
As been stated and the responses that have been made by the defense counsel, I feel like we are already arguing the same application. I will agree with the prosecution that by allowing bond to the respondent's hearing straight away defeats the purpose of hearing the same application, which sentence around the issue of custodial orders that is being sought by the investigating officer. Therefore, we direct the proceed straight to hearing the same application in the rest cases undertaken in the coordinated commissions.
Most obliged.
Most significant.
We will do the execution. Mr. Prosecutor, it's your application. The only thing is that the suspects can sit in their seats, so please do sit where you are. Sit.
application before this court, seeks for custodial orders for the 23 respondents. We have in custody. The 23 were arrested yesterday. In the Nairobi Central Business District and were put at Central Police Station by OD number 60, /30, /12, /24. The honor, the application hearing is supported by judges from by one Corporal Anthony Kirin of the DCI, Nairobi Central. Your Honor, in the same notice of motion, that is in paragraph B, and in the supporting affidavit, paragraph 2, the deponent of the said affidavit indicates that he is seeking for the same period as is currently investigating offenses of incitement to violence and disobedience of the law, contrary to section number 96 of the Penal Code. Taking part in unlawful assembly, contrary to section 78(1, as read with section 79 of the Penal Code, and creating disturbance in a manner likely to cause a breach of peace, contrary to section 95(1) of the Penal Code. Your Honor, further in paragraph B of the notice of motion, is indicated that the suspects' mobile phones need to be taken to the communication authority for extraction and inform the same are in the custody of the officer. Paragraph E is yet to obtain CCTV footage from the nearby establishment. Paragraph F is yet to record witness statements and finalize the investigations. Most importantly, in paragraph H, it is indicated that the respondents are threat to peace and stability of the country as they continue to exercise members of the country. Your Honor, it is not in dispute that this court has the ability to grant bail and bond if it is so convenient. Said rights can't be limited when the court is given reasons why the same should be denied. Your Honor, I've indicated that these persons were arrested yesterday. And yes, the police officers issued cash bail. But the reason why the same was not granted for the person before. Your Honor, investigation are yet to be completed. There is a possibility of the accused persons of them appearing with the evidence that is or show that the IO intends to acquire in the 14 book. And Your Honor, the same is as provided by Section 58 of the National Police Service Act. whereby it's not of semantics that will be granted upon arrest, especially when there's a threat or there's a continuance of committing of the state offense. Your Honor, they have been told the same suspects were produced or bailed in court within the requisite time of 24 hours provided in the Constitution. Your Honor, unfortunately there are some other ongoing, other proceedings, counsel have confirmed in the High Court. And that the application before this court is proper, pursuant to section 36A of the CPC, whereby where an officer having arrested suspect has to produce them in court within 24 hours. There is need for the officer to require more time. The same should be done in writing and presented before court with the results. Your Honor, the said writing and the result are contained in the application.